Yes, good morning, Mr. Chairman. My name is Laura Tamez, and I am a former president of the Texas Trial Lawyers Association, and here on its behalf to respectfully testify against the bill. Thank you to Senator Hagenbu for visiting with us about our concerns so we could have a better understanding for the impetus of this bill. And I'm going to turn my attention to page 1, line 12 on the definition of the motor carrier safety improvement. But let me start out by saying we honor and applaud Senator Hagenbu's attempt to improve safety for the motoring public. I've learned that is important to him. But the definitions there are determinative of employee status. And we also learned from the visit that sometimes owner-operators may come back and seek workers' comp, for example, in the event of a crash and they're injured and or killed, but they are not employees. They are independent contractors. So went back, did our research, and under the Labor Code 406121, there is an explicit definition of an owner-operator as an independent contractor. So that explicit definition could potentially conflict with all of these other factors that have been included in the definition. 401622 of the Labor Code also explicitly states that an owner-operator is not an independent contractor, and what happens in practicality is there is a lease agreement entered into that may address workers' comp most of the time, and many times owner-operators have to sign or enter into a lease agreement that says we're responsible for our own employees when it comes to workers' comp coverage. And so we are happy to work with Senator Hagenbu and the proponents of the bill to make sure there's clarity and not some conflict that would create unnecessary litigation in those factors.
All right, thank you. Please state your name. Alan? Adam.
Thank you, Chairman Nichols. My name is Adam Blanchard, and I am the co-founder and CEO of Double Diamond Transport, based out of San Antonio, Texas. To begin with, Senator Hagenbu, we appreciate your authorship of this bill and your support of our industry. I know you're also in the industry and understand the needs that we have. I'd like to spend this time and certainly welcome questions at the conclusion of my statements, but I want to talk with the members of this committee briefly about how this works in practicality for us. We as an industry are governed by the U.S. Department of Transportation, specifically the Federal Motor Carrier Safety Administration. The FMCSA states that companies like mine, I have about 100 trucks that are independent contractors, that they want a single carrier responsible for safety. And so we have our license through the FMCSA, and when we have individuals out there that have advanced their career by purchasing their own truck, they lease on to fleets like ours and then operate those under our authority, so there is a single carrier responsible for safety and the requirements by the FMCSA. With the evolution of the technology in our industry, specifically after 2018 and the ELD mandate, there has been a huge proliferation of technology, specifically related to electronic logging device, camera systems, and the like. Companies like ours need this exemption because there are attacks out there against companies in terms of the classification. We need the ability to be able to implement those very necessary safety devices without the fear and the risk that it will somehow inhibit or interfere with our ability to identify these drivers as independent contractors. And I think it's important to note that when you go from being a company driver to an independent contractor, you're usually about doubling your salary. And so any indication or suggestion otherwise that this is affecting just support for big companies, this is truly the middle class. These are the individuals out there that need this support so we can continue to provide them those financial abilities. We appreciate your support. I'm here for the bill. Excuse me. Thank you.
Thank you. Any questions? Senator Johnson.
Thank you. Mr. Tamez, like you, I applaud what's going on here, but I am confused. No, I don't quite understand how you would propose to improve the bill, and I'd very much like to hear you and Mr. Hagenbu talk about what you'd like different here, why it would be different, and why Senator Hagenbu, why you think it's such a great idea or not.
Yes, so
you have to cast a vote.
Right. No, I understand. The list of factors that have been created, and again, we're proponents of adding safety features and not risking that creating an employee status question, right? I understand that, and we worked with another stakeholder last session to make that happen. But in terms of when you start getting into training, operating procedure, policies, then that blurs the lines of employee status versus independent contractor. So if the concern is that an owner-operator who is truly an independent contractor that has a lease agreement with a motor carrier comes back and says, you know what, I'm entitled to workers' comp, or the family comes back and says, I'm entitled to workers' comp, the labor code has addressed that specifically, not just for all industries, but specifically talks about motor carriers and owner-operators, and specifically states they are independent contractors for the purposes of workers' comp. They can enter into an agreement. That agreement will be honored under 406-122 because that specifically defines status as an employee. So adding a crash avoidance system shouldn't come into play if it's explicitly stated in the labor code.
So if this bill simply said motor carrier safety improvement means any device, equipment, software, or technology, you'd be fine with it.
Right.
Where you have a problem with it is where it says or procedure or training or policy or program or operational practice, because that gets into what employers typically do with employees. And I know we have somebody at the table wanting to comment on that, but I'm not sure.
And we do have one more witness after this.
And you are correct, Senator.
Thank you.
Okay, Senator Hagenbu, of course, it's your bill.
Yeah. These systems are only useful if you can follow them up with the training associated with that. So that's the very purpose of the bill, is to say there's an exception to the labor law if you're talking about this safety equipment and using it not only just to, say, take a video of a driver facing inward and say he made a mistake, or he says the technology is telling you he's braking too fast or he's speeding too often, to bring him in and have a talk with him about it. It's of, you can see where it's of no value if you can't correct someone and use that. It's like collecting data and doing nothing with it. That's the very purpose of the bill, is to say, let's make sure that we're making sure these motor carriers are protected. So when they use the systems, including the training associated with them, that they can get the effect they want, which is to improve their safety and the driver's safety, that they are not going to be in violation of the labor law and later on be miscalculated as the owner operator as an employee driver.
Okay. Was that a question? I don't think that.
No. I was just trying to. I'm sorry. I thought I was sort of just trying to help answer different perspective on the.
Trying to manage the meeting here. Go ahead.
And I believe there was a court holding fairly recently finding that Amazon, which had used a third party, which had used independent contractors, was actually the employer. I'm not familiar with the legal reasoning in the holding. Would this bill affect the outcome in that kind of holding?
Well, the federal regulations deem owner-operators as employees many times, unless there's some exception to it, different from Texas. Texas uses a different test called operations and control and direction. So that's where the difference comes, if you're interstate or intrastate.
Okay, and thanks for the indulgence, Chairman. I promise it's the last one. If there were a qualification in this paragraph 2 that qualified procedure, training, policy, program, or operational practice associated with the use of the device, equipment, software, technology, would we be closer to harmonizing the code provisions?
We can definitely strive for that harmony.
Thank you.